5:30 calendar in custody. I understand we have Ms. Collison's case first. And
Yes,
is that
Your
you
Honor.
at the Thurston County Corrections?
Yes, Your Honor. I'm here with Ms. Callison.
Thank you, counsel. We're here first on a conditions review motion by the city. Whoever wants to take that.
Thank you, Your Honor. Isaac Fortunato on behalf of the city. I guess I would like to start out by asking, and I wasn't sure after hearing from counsel if they still intend to proceed on the 1077. That's going to kind of inform how I intend to proceed on this proceeding.
Okay.
And I guess I would defer to Mr. Pezdirka on that. I know that there was not a 1077 entered yesterday at the preliminary appearance up in Superior Court.
Okay. All right. Thank you. Mr. Pezdirka?
Your Honor, yes, we are still requesting the 1077, and we'll be able to provide an updated order to the court shortly. My office is working on that.
Okay. So you've had the chance to speak with Ms. Callison and feel there's competency concerns?
Yes, there are still active mental health concerns.
Okay. All right. Very good. Thank you, Mr. Pezdirka. So with that in mind.
And Your Honor, in that case, the request of the state is going to be for an inpatient or an in-custody competency evaluation. The basis of this request is, Your Honor, I provided counsel and the court, and I believe those are in the court's file for this case. And I had spoke with the clerk, and I believe she had indicated that you may have reviewed those. There are a series of allegations of new violations of the same order, all occurring, the same week that this court imposed the order last Monday. It was actually, Your Honor, that was on the bench when this order was imposed. I'm happy to go into more detail about the safety concerns that I have. It's my understanding the alleged victim in the underlying stalking case, the protected party in the order, is also on the Zoom call and may wish to be heard. But understanding the nature and the number of allegations of violations of this order, including most recently the allegation of the Superior Court, not only violation of this order, but also the malicious mischief in the first degree charge. The state does believe that an in-custody evaluation is appropriate. I would be happy to go into further detail if the court or counsel need that. But I was also curious, I had spoken with the clerk, and I didn't know if we wanted to proceed on including all of those other charges that had been subsequently filed, including the 17305 ACT, 17307 ACT, and 17308 ACT cause numbers into this request for an in-custody competency evaluation. I think that makes sense, understanding the special nature of the case.
Thank you. I think that makes sense as well. I'll turn to Mr. Pezdirka first with respect to the motion for change in release conditions, but I do think that if there's competency concerns currently, then it makes sense for each of the cause numbers to be included in the competency evaluation. So we'll go ahead and do that moving forward. But Mr. Pezdirka, with respect to release conditions.
Your Honor, and I guess I may have missed it in the Mr. Fortunato's comments. My understanding that Ms. Callison is now being held on bail in the Superior Court cases. Our request at this time is to maintain her release. If the court does feel that bail is necessary, we would ask it to be nominal. Further, and I guess this is where I'm not clear about the comments. Obviously, if she is still in custody, it would be our request for it to be in the evaluation to be in custody. I don't know that the city is able to make that request as a standalone request, that it be ordered to be in custody rather than be based on whether she is in custody or not. That is what my office is preparing, as an order that reflects that she's in custody and for that evaluation to be done. But our request is that she either continue to be released on this matter or nominal bail to be imposed so that she has the opportunity to be released on this matter. And obviously, if she is subsequently released before that evaluation is able to be completed, we would submit an updated order at that time.
And Your Honor, I'll clarify. My position is certainly that that release be revoked on the new charge and that she be held on. My request is $250,000. The basis for that request is, not only the number of allegations of violations of this order within a work week, but also, the increasing severity of the allegations here, culminating in on Friday, the 19th, an allegation that she drove to the victim's house, was driving near it, got pinned in after she drove into the victim's car, and ultimately ended up cutting her own throat in front of law enforcement. There are serious community safety concerns, really, and even ending in that allegation of violation. The city even has some witness intimidation concerns, given the sheer volume of allegations of violations of this order and the nature of the newest charge. Being outside of his house, driving into his car, and even slitting her throat. And in that scenario, I will also mention, it's worth mentioning, and I think the court has understood this. Ms. Callison is pregnant with the victim's child. All this to say there are serious community safety concerns, and perhaps even more serious concerns about interfering with the administration of justice. Understanding that it was this court's order on, I believe it was September 15th, that she abide by this court's orders. And that includes the no contact order that, as I looked back at that hearing, Your Honor was very clear about what that order meant. And notwithstanding that, we are here on 5 charges within that amount of time. All that to say, I do think that there are just no lesser restrictive conditions of release that will ensure that she abides by this court's orders.
Thank you, counsel. So I think before we move on to the 3 backup matters for which there's been complaints filed, on conditions review, so the court is going to modify the release conditions for following reasons. Number one, under the court rules, under 3.2, the court is able to revoke release if there's clear and convincing evidence of a willful violation of pretrial release conditions. The state has, or the city has provided the court with documentation, police reports, probable cause declarations from cases that have not yet been charged, but also out of Superior Court, that I believe does meet the standard of clear and convincing evidence that there has been violations of the pretrial no contact order. So on that basis, I believe it is appropriate to revoke personal recognizance release. Additionally, this new information creates a situation where the other factors under 3.2 need to be considered, specifically whether there is a significant risk to community safety or to the alleged victim in this case as well, given the allegations. So based on all of that, I think we did try 3.2 provides that the court needs to impose first least restrictive means when there are concerns around safety. We did try that at the first hearing with the imposition of the pretrial no contact order. At this point, given the evidence that there hasn't worked, I believe bail is at this point appropriate. Superior Court felt an appropriate amount for those charges to be, it's like $37,500 for each, so $75,000 total. So I think given the findings in Superior Court as well, and that subsequent action since the last hearing, bail in the amount of $20,000, I think is appropriate. The court is required to take into account the defendant's ability to pay, and given that she has court-appointed counsel, these are significant amounts. I'm cognizant that she's already in on $75,000 bail, so I believe $20,000 is appropriate in this case. So that is with respect to matter 25 DV 0917. And I think at this point, we will need an amended 1077 for an in custody competency evaluation, since she is now going to be held on this case. We'll need that. With respect to the backup matters, if there are competency concerns, we'll want to move forward there. I believe, though, we will need to establish probable cause before the court can consider holding her in custody on those or setting other release conditions. So, counsel for the city, are you prepared to establish probable cause?
I'm happy to. I did provide counsel with copies of all of the incidents, and I'm happy to establish them. I don't know if counsel's had the chance to review them or if they would stipulate. If not, I'm happy to establish.
I have not had the chance to review them. I'm not sure which person in our office he provided those to. I have not seen them.
Okay.
Do you swear or affirm that the testimony you're about to provide the court is the truth and nothing but the truth?
I do, Your Honor.
Go ahead.
I will start with the case from September 17th, 2025. This is the case number 17305 ACT. On September 17th, 2025, at around, this would have been 10:30 p.m.
And I'm sorry to interrupt. Can you give me the last two numbers of the matter you're on again?
Yep, this is 305.
305, thank you. Okay.
Yes.
All right, go ahead.
On September 17th, 2025, at around 10:30 p.m., Tumwater Police Department was dispatched to a residential address on Honeysuckle Lane in Tumwater, Washington. The reporting party, and Mr. Robert Cantrell, reported that he'd received a number of phone calls from an unfamiliar number, which was at Providence St. Peter's Hotel. He indicated that the phone call was likely from his ex-girlfriend, a Miss Cody Callison, a person who had attempted to call him previously. He also confirmed that there was an active no contact order out of this court, which prevented her from having any communication, including electronic communication. He said that he had not answered the calls, but later did call the Providence St. Peter's hotline. They confirmed that a call had been sent. They confirmed that a Miss Callison was there, and a nurse later told the officer that she had observed Miss Callison have access to a phone and had saw her on the phone at the same time of the call.
I'm sorry, the last, let's see, I'm looking at the reporting officer narrative for, let me just make sure I'm on the right one, 305, confirming that Ms. Callison was currently admitted to the behavioral health wing of the hospital. Mm-hmm. The nurse could not confirm whether Cody had made any calls or access to a phone.
She had been able to have access to the phone and had seen her on the phone at 22:50 hours making outbound phone calls.
Oh, you're on the different, okay, thank you.
I apologize if I led you to a different report, Your Honor.
Okay, thank you. Let me just read that. All right, so Mr. Pazderka, do you have any position on probable cause?
No, Your Honor.
All right, the court's going to find probable cause, understanding a reasonable basis for believing a crime may have been committed, given that it sounds like this was allegedly from a different phone, but from a place where Ms. Callison allegedly was, and some testimony on her access to a phone there. So I believe probable cause standard has been met. So court will find probable cause in matter 17-305. And go ahead with your next one.
On September 18th, 2025 at around 21:51, so that would be.
Which case is this one?
Oh, forgive me. This is the September 18th case, so this would be the case number ending in 307, Your Honor.
Thank you.
At approximately 8:51 p.m., Tumwater units were dispatched to a protection order violation at the same Honeysuckle Lane address in Tumwater. The reporting party was also a Mr. Robert Cantrell, who'd indicated that his ex-girlfriend and Miss Cody Callison had called him in violation of a protection order. That would be, again, the protection order out of this court, which, among other things, prohibited her from having any electronic communication with him. At one point, Mr. Cantrell had received a phone call. He did pick up one of the phone calls. He stated he identified it as Cody by recognizing her voice. This was a phone call that was received at about well, it looks like it was at around 10:41 p.m.
All right, and Mr. Pezdirka?
Your Honor, no position at this time.
Court will find the probable cause standard has been made in this case as well, given the allegations provided in the police report. All right, and that leaves 308, if I'm
Yes, Your Honor.
mistaken.
On September 19th, 2025, at around 5:48 p.m., Tumwater Police Department was dispatched to a possible protection order violation via text, the same Honeysuckle Lane address in Tumwater, Washington. The reporting party was also a Mr. Robert Cantrell, who indicated that he had received text messages in violation of an active protection order out of Thurston County District Court, which, among other things, prohibited the restrained party, a Miss Cody Callison, who was his ex-girlfriend, from contacting him electronically. He was able to provide a text message that was sent or received rather around 5:20 p.m. He recognized this as being sent from Miss Callison's number. The text message apparently indicated that he had been dating other women and states that he is a liar and a bad person.
Based on that, there's a reasonable basis for the charge. The court will find probable cause in that matter as well. Having then found probable cause in each of these matters, court will set an additional $10,000 bail on each of these under 3-2, finding there to be no reasonable alternative to the imposition of bail given the community safety risks in this case. So given that she'll be held by this court on all 4 of these cases, we will need a 1077 reflecting each of the cause numbers, indicating an in-custody competency review. I believe we received the original 1077 from the city, but if either party has one, they're able to send the court. Take a look at that.
And forgive me, counsel, did you say that your office was working on one? If not, I can draft one up quick while we take other matters, and I can make sure. I don't know if Your Honor has to stay on the bench to sign that.
Don't think so. No.
Probably.
Yeah. Okay. No, I think. Yeah. I'll stand by while.
Okay. Okay.
I believe Judge Buckley takes over.
And my office is actively working on that, Mr. Fortunato. So.
Wonderful. Wonderful.
Oh, great. Okay. All right. Sounds, yeah, so it'll just be excluded, period. Okay. So then there'll be an excluded period between the complaint being filed and the probable cause finding, and before the arraignment, that will be excluded. So let's, while you're working on that, maybe we'll get it by the time we've set the next hearing, but if not, I'll stick around until that's available. What we can do is we'll set a hearing 2 weeks out, at least 2 weeks out, if the competency evaluation comes back earlier, obviously you can ask for her to be calendared sooner. But are we can do October 9th? Okay, we'll do October 9th. I'm cognizant of the fact that the judicial officers here and several of the pro tems have a conflict, so it will most likely be me again. Yeah, and so October 9th works. Okay. All right, thank you.
That'd be straight to the 1:30 calendar?
Yeah, straight to 1:30.
Thank you.
Yeah, okay. All right, yeah, that's true. All right, so I'm going to do the J and S's for the cause numbers again. This might, since there's 4 now, if the 1077 comes in, I'll take a look at that now.
And I am about to email that to the clerk, Your Honor.
Thank you. For the newly the new matters, additional in addition to bail, there'll be conditions not to commit a criminal law violation and compliance with the existing pretrial.
Your Honor.